I think is the session starting already?
In about 2 minutes, Damlola. Good evening, everyone. I trust we're all doing very well. I wish you a happy Thursday. My name is Folarin Aluko, and I'm the chairman of the Nigerian Bar Association Garki Branch Continuing Legal Education Committee. I also have the privilege of being a past chairman of the MBA Abuja branch. It's a pleasure to have everyone here. I would like to say a big thank you to our branch chairman, Mr. Bamidele Ojo, Mr. Anthony Bamidele Ojo, for his innovative policies, which have led to several interventions, including this intervention or this knowledge sharing session. So thank you very much to Mr. Bamidele Ojo and his very indefatigable EXCO. I would also like to quickly recognize a member of the EXCO who is with us, the publicity secretary, Damilola Victoria Alabi, who is wearing two caps. She's also the head of the ePlan clinic. I'm also wearing another cap with regards to ePlan, but so welcome, Damilola. I see a couple of other members of the former EXCOs in the house. I see Mr. Selzing Zingfa, former social secretary of the branch. All protocols duly observed. So thank you, Mr. Chairman. Thank you, distinguished EXCOs. And I would also like to say a big thank you. This is the second part of a two-part conversation. We had the first session last week. Speakers from the first session are here with us to take us into or to share their thoughts on this very interesting part, this very interesting component of the entire website development dispute conversation. So thank you to our facilitators who are present, Mr. Kayode Adeniji, Mr. Victor Idowu. There's a facilitator who has promised he will come. I'll see, we have a special guest. I'm hopeful that he'll be able to join us. He's actually not in the country at the moment. He's in another time zone. I'm hopeful that he'll be able to join us sometime soon, but he'll bring a very unique perspective to this topic of this conversation. In the course of the week, I was talking to someone, Mr. Bulus Atsen. I'm not sure if he's here, but he mentioned, and I think it is something that is worth repeating here, that the fact that that participants that we did not sign. You know, as lawyers, first of all, and as business people, everyone should have. We should all have websites. You know, but for the lawyers in the house, the fact, and for those of us who have a website, one website or the other, whether it's a personal website or a firm website, it's important to note that the fact that we did not sign an agreement going into the creation of the website doesn't mean that one cannot enter into an agreement or at least create some sort of documentation to guide the relationship, you know, going forward, and to avoid situations that may, you know, lead to conflict. But we're here to discuss some very interesting innovations or innovative ways in how to resolve these conflicts. Like I had mentioned last week, Mr. Victor and I were recently just involved in trying to resolve a particular conflict. And somebody kept asking for, give us access to the back end, give us access to the back end. And when they were giving access to the back end, they didn't even know what you know, they were to do at the back end. So welcome once again. I hope we have all brought our questions. Please, if you have any questions from last week, very critical, please feel free to raise them. We have a special, I was talking to Mr. Victor Edo and Mr. Kayode. We have a special, there are some special announcements that we'll make at the end. So I would encourage us to please stay on. And then with regards to housekeeping, for those of us who will be looking forward to filling out, to claiming CPD points, the questionnaire will be shared in the middle of the webinar. Shared in the middle of the webinar. And I would encourage us all to please fill out the form. And yeah, please ask your questions. You can use the chat room. And in the event that, I mean, at the end, I would encourage us to take this conversation outside Zoom. You know, there's a broader context that website development agreements fall under, and that broad context does require some looking into, especially for the lawyers from a business development point of view. But having said that, I would like to say a big thank you to all our participants. Thank you for joining. And with that, I will pass the mic to Ms. Asma Ahmed, our amiable moderator. So Asma, over to you.
Good evening, everyone, and welcome to the second segment of this webinar. Our speaker today is Mr. Kayode Adeniji. Before I go on to do my introduction, now, first of all, I'd like to read out his profile. Mr. Kayode Adeniji is the senior partner at Laurels LP and Arbitrators. He is also the founder of All Arbitrates. His legal argument in the landmark case of Megawards Nigeria Limited versus Incorporated Trustees of Bagada Phase 2 Residents Association produced the groundbreaking judgment of the Federal High Court in the right to freedom of association. Kayode Adeniji played a major role as a legal advisor and representative of a major shareholder in the Econet Airtel International Arbitration, one of the biggest and most complex international commercial arbitrations in Africa. Please, let's welcome Mr. Kayode Adeniji. Is he on board?
Yes, he is.
Okay.
I think you have to ask him to unmute. No, you might have to ask him to unmute.
Okay. Okay, can you unmute yourself, Mr.
I just made him
Yes.
call.
Yes, I've just been able to unmute myself. Thank you, Mr. Chairman. Mr. Bamidele Ojo. I am really grateful for this opportunity. I do not take it for granted. I think that I want to say this to the chairman of the plan, our emeritus chairman, Mr. Folarin Aluko, that what we are doing, we are going far ahead of our generation in terms of legal practice and the practice of law. Because the area that we are talking about today in other nations of the world is still an area where people are still trying to put their heads together to know and figure out the perfect regime and structure for them to be able to govern this area of human endeavor, which is the life of man online. I just want to commend the chairman and the organizers of this webinar, because the topics we are talking about, I want to say sometimes I feel that it is beyond us, because if you were practicing law maybe 20, 30 years ago, these were not things that people were discussing. So I want to say that Abuja branch, to me, is one of the most forward-thinking, most futuristic, creative and innovative branch that I am experiencing right now, having this discussion. So I'll just go straight without much ado to
Okay,
my
sir.
piece.
Before you go on, sir, thank you very much. It's Gariki branch, not Abuja branch.
Okay, so
Thank you.
Garki
Sorry.
branch. Yes,
Yes.
so Garki branch. Thank you.
So, sir, I would like to make my introduction. Then I'll ask you my question, sir.
Okay.
So, yes, sir. This segment focuses on resolving disputes in website development contracts, but more
Yes.
importantly, on how those disputes can be prevented through better negotiations and documentations.
Thank
So,
you.
sir, my question is this. We're not here to debate on coding, but to help lawyers and business owners to understand. Yes, sir.
Asma,
Yes, sir.
maybe Mr. Kayode should finish his presentation, then you can go into the question. You can frame the
Okay.
questions for.
That's okay, sir. That's okay, sir. You can go on with your presentation, Mr. Kayode. This floor is
Okay.
yours, sir.
So I will just take it from your first question, which is the fact that how do we prevent even dispute arising in the first place? And the best way, we as lawyers, the best way to prevent disputes, because my own initial experience as in-house counsel in Honeywell is that you are being appraised by the fact that you are working to ensure that the company does not go into any legal dispute. And you must be able to do that from the point of agreement. The clauses you are agreeing to, the terms that we are drafting. It is the job of the in-house lawyer to ensure that those clauses are drafted in a way to prevent, any argument that might come up in the future. So, and one of those ways is to ensure that one key point I would like to make in website development, one key clause that we were able to put in the one I did recently is the fact that even when there is disagreement between the developer and the client, there must not be downtime. For example, I have a contract with a developer. I am not able to pay the developer as and when due. The developer does not have, we draft in the agreement that website tools and everything that contributes to the building of the website must not have a downtime, even at the time we are having disputes, whether about money or about intellectual property or any other dispute we are having around it. Let the website run. The implication of that is, if I refuse to pay and my website is down, it means that I am being crippled. If I feel that the website developer has not done something right and maybe I withhold the money, he has a right to go to arbitration. But at the time when we are initiating that or triggering that dispute, the website should still be up and running. Because what happens is that if there's a downtime for 1 week and you are going to either court, because that's the traditional way of resolving disputes, you file in court, the bailiff or the sheriff will tell you that they are going to give you a date. The court will not sit at a particular date, and you have to be going back and forth, calling court clerk to fix a day for hearing. While your website is down, people are calling you. People are trying to make orders. And in the split of that 1 week, a business can die. So we ensure that if we are going to have any dispute at all, let the website continue to run. If you are going to claim any amount after that, the tribunal or the court or anyone who is going to adjudicate the case will show that, yes, this is the amount you are being owed, and then they can give you such award. I hope that is clear. So the best way to resolve a dispute of this nature. So I'm also going to paint a picture of me. I'm also going to create a picture of me refusing to pay my website developer. And the website developer stops the website. Nothing works on the website again. And he goes to court to file. When he's filing, I need to reply. And I'm telling the court that he should, my prayer before the court is that my website should be restored. I'm asking everybody on this panel or on this webinar, how long do you think I'm going to spend in terms of time for my website to be down while I am going to court to ensure that I have my case heard? With all our experience in litigation, dealing with the courts and the clerks, what do you think is going to happen to my business the website and my business as a whole? I would like some people to just pop up comments or answer to my question. How long do you think I will have to wait for my website to be up and running based on what I just said earlier on? In the Nigerian court system of today, I am looking for comments. Has anybody said anything about how long? Somebody said 100 years. Don't say it. What if we have lawyers from other jurisdictions listening to us? Please, so let us market our legal system very well. Please, we need please, can somebody tell us, based on our dealings with, as long as the court determine the matter? Okay, 99 years. Oh, 2 years probably. Wow. So what if I am maybe I have a senior advocate of Nigeria on my own side and he's trying to get it? Will it reduce? So 5 years or more. Okay, what if I have a senior advocate on my side to do it? Can we do it? No, don't let us talk about Supreme Court, just the High Court. Okay, 3 to 5 months. Yes, like I saw 3 to 5 months. So if we get like a senior advocate, he knows maybe he has a relationship with the clerk or whatever, they can expedite the action. So 3 to 5 months. Does anybody have any shorter period? If the case is fast tracked, okay. If the case is fast tracked, like how long do you think it will take? Yeah. So let's even say 2 months. So do you think that, let's say 2 months, 2 months is the smallest that we have now. Thank you. Thank you all for your contribution. 1 to 2 months. Yeah, it will take less than 2 months. So 3 months. Thank you. Thank you. So let's say 1 to 3 months. Now, do you think a business can survive? Let's say it is like an e-commerce business that is in 3 months. Or let's say like a banking app or a fintech company. So that website is going to be down for 3 months. Can we all imagine what that will do to that business? So that is the reason why when you go to this international conference, business conferences, people will tell you that there are some countries they don't want to do business in. And when foreigners begin to tell you that, oh, I don't want to do business in that country because I don't know when the court I don't know when my matter will be heard. And there are no clear rules, there are no clear timelines. This is how we as lawyers, this is why we lose money. Because when foreigners or foreign investment don't come to us, don't come to our country, they are not flooding everywhere. It means that our job as lawyers, our work will be limited. The small amount of international investors we have in Nigeria, they are probably with the senior lawyers and they are collecting their dollars, and a whole lot of us who are thriving, brilliant, intelligent. A lot of lawyers may not be able to boast of an international clientele. So the reason I'm saying this is that the answer to everything I've just said is arbitration. So if you have it in the clause that this matter today in Nigeria, you can hold that same 1 to 3 months. You can have arbitration from beginning till the end within 3 months, and you will conclude to the final award in Nigeria of today. And I'm not sure that there is any country that has the technology that can make that happen except Nigeria. And that technology is all arbitrate. So we are trying to ensure that all lawyers in Nigeria, the service industry in Nigeria, the legal service industry, can be fast-tracked. So I'm just going to go straight to it because I don't want to talk through the points. Can you go to the next slide, please? I'm going to finish my slide in the next. Oh, what is arbitration? Arbitration just means private litigation. That parties agree that when there's a disagreement, we are not going to court. We are going to organize our own court system. And that's why we have the New York Convention of 1958. All the nations of the world agree that if I want to do business in your country, I don't know lawyers. I cannot be going to Igboshere or Abuja looking for lawyers. I can probably do it online. Let me now say that, what if the website developer is in another country? Will I be going to Federal High Court or State High Court in Abuja to bind the person in another country? No, because that person is from another country. You probably don't want to trust our own court system because it doesn't know it. So that's why countries agreed that we all honor each other's arbitral award, that allow us to have arbitration. That's what arbitration means. Arbitration is not for some special people. It just means that we can do business across borders and our lawyers can represent us. The next slide, it talks about different kinds of arbitration. Compulsory arbitration just means that once you have arbitration in an agreement, both of you are bound to go to arbitration process. There are times when lawyers are being advised by judges that, but in this agreement, there's arbitration clause. Why are you coming to court? Some lawyers just have a mindset or a mentality that arbitration is for some special people. No, arbitration just means that you organize your own private court. Now, the one I want to touch on is the ad hoc arbitration. Ad hoc arbitration is the foundation of arbitration. It means that it is between parties, that when both of us agree that we don't want to go to court, is the basic principle of arbitration, meaning that allow parties to control the process of settling their disputes. If they want to meet in the house of the other party, they can meet there. If they set the venue in the bedroom of another person, they can meet there. If they appoint a third person to adjudicate or to mediate on their matter, anything that third person says or any award that third person gives is binding. The court will respect it. The reason why the court will respect it is that both parties have agreed that this person has integrity and he can deal with our case. And that's why the court will not listen to any challenge against arbitration, except you can prove that this particular person has acted in a way that is not fair. That's the only ground for challenging arbitration award. So I want to tell everyone today, the alternative to litigation, to alternative for us to be faster as a lawyer, to be smarter as a lawyer, to make more money as lawyers, is arbitration. The next slide, please. So we're just talking about time and cost efficiency. People also think that arbitration is very expensive. Yes, when arbitration just started, people charge in dollars. People will appoint arbitrators, and arbitrators will give them one charge, and sometimes the parties will run away. But in this age, you can appoint arbitrators by the click of your finger on a website like Arbitrate. You can appoint people who are retired judges who don't do any judicial work anymore. They are just sitting at home, waiting for an arbitration case that they are going to sit on. They are in their houses, former judges. So imagine that a former judge of the Federal Republic or Federal High Court or a state high court is sitting on a matter of, like, say, let's say the matter is so small, 10 million. And arbitrator says, okay, out of this 10 million, can you pay 10% of the cost of arbitration? And then you are able to have your arbitration between 1 or 2 months or 3 months. Imagine what that would do to your client, to say, wow, my lawyer knows how we can go about this case, and the case will be concluded within months, not years and 100 years that everybody was mentioning. Imagine the money you make there as a lawyer, and you can move on to the next case, as against staying on a case for 10 years after you have collected maybe just 3 million. Let's go to the next slide. Confidentiality. Yes, it's a confidential system. Arbitration, you are not supposed to invite. There are so many details that might happen in that agreement that you don't want the world to know. So me, about my website, now everybody knows that my website is down, but they don't know the reason why my website is down. But suddenly somebody comes to court one day for their own matter, and they are hearing that my case is being called. They now realize that the reason why this website is down is because this man didn't pay developer. Just imagine the embarrassment and the kind of reputational damage that would have for my company. But if it were to be arbitration that is securely online, nobody knows. In 3 months, just like everybody said, we will resolve it, even though I have lost money while my website is down. But at least in 3 months, if it comes up, people will not know the reason, and they will be saying, oh, your website was down, you have to give me my money. Or, people go on Twitter and they drag you. But right now, if you finish it in arbitration, you can come out again and say, oh, we are sorry, and put out a statement, because the arbitration you have had is a confidential process. Next slide, please. Yeah, the privacy and autonomy. But the one I really want to mention is the specialization. Somebody designed a website for me, and I am going to a judge or an arbitrator who doesn't know anything about website development, doesn't know what is called back-end, front-end, doesn't know what is called user interface, doesn't know what is called chat box and code writing and anything. Do you think that person will be able to judge that case efficiently or perfectly? No. Yes, our judges they know all the laws. But you see, in the world we are right now, that is being taken over by AI, a website dysfunction or a website fault could even be a fault of a faulty LLM. That is the large language models of AI that could disrupt a particular website. How that occurred, how that can be, remediated, how that can be resolved. You need an expert, somebody who is grounded in that sector, to be able to look at it and give a final or a partial award, whatever the case may be. So arbitration allows you to look, you press on your button, you look at the profile of a particular arbitrator, because not only lawyers are arbitrators. You can have somebody like our resource person, our facilitator in the last lesson, who is a website developer, as an arbitrator. And he can tell you that from my experience as a developer of website, this is what happened. This is what happened. This is the award that is likely to, put you in that original place where you are before the breach happens. So in arbitration, accountants are arbitrators. If you have a construction contract, especially property, architects can be arbitrators for them to know that, oh, when did you bring the tools? When did you start the construction? How much did you import? Okay, after dollar went up, how much is remaining? Those are the kind of people who are in the business, and they can determine how much of cost or loss you have suffered. So arbitration allows you to choose a specialist to be able to explain things to them. But what we do is that we are stressing our judges. Most of them write in longhand. Now you are coming with a very technical issue after they have sat down on election petition, they have heard criminal cases, and then you are bringing all of that. It is very stressful, because judges are supposed to think very deeply about a particular case and give very sound and deep judgment. But you see, when we load them with all these things without, proper preparation on their own side, you are just going to get anything you go there to get. That's what you will get. And they certain awards or costs, and you are like, this cost is too small. That is what you are going to get. You might have suffered 20 million and you are being awarded 3 million. That is what you will get. Because for them, they are just being careful. So we also need to know that our judges are humans, and we cannot continue to stress them with cases that need specialization. And there are people available all over the world who can sit on matters like this. Can I go to the next slide, please? Cross-border effectiveness. Yeah, I think I've mentioned that as arbitrators is about cross-border, effectiveness. It's international in nature. And when I became a lawyer, I didn't become a lawyer so that I can be a lawyer just to local clients. And all of you will agree with me that it will be a very good thing for us to earn in dollars, to earn in pounds. And the only way to do that is if you have clients who are outside, who are looking for legal services, and they can find you on a particular website to say, oh, I invested in this person is breaching my contract, I need a lawyer to do it. Most of the people outside right now, they don't want to they can't come to Nigeria to do it, because litigation means that somebody has to come to Nigeria to fly in, and then sometimes the court might not sit. They want to be there. They want to be able to witness an arbitration online and just finish it within 2 or 3 months. So any lawyer they find who is agile enough, who is smart enough, who is intelligent enough, and is in the web space, they are willing to take them on and say, please help me with this particular case. And then you can charge your money, whether in dollars, and you know that you are not just doing local law, but international law. The next slide, please. All Arbitrate. So All Arbitrate is a digital platform designed to take arbitration and mediation fully online, from initiation to resolution. So what we want to do is that we want to have lawyers and arbitrators who can sit with their computers or their phone, and they can hold arbitration proceedings online. So the era of a venue where you choose a hotel or a conference center where they are charging you 1 million for 1 hour, and the arbitrators will come and charge in dollars, we are reducing all of that so that our legal practitioners can embrace arbitration as a way of life, and people can earn per case, and they can finish their cases on time. Key benefits of using All Arbitrate platform to resolve disputes. You can be anywhere in the world, and you can still be practicing law and be earning money. That's what it means. I know lawyers who have, some of them who still pay practicing fee. They are in the UK, they are in Canada, and people pick up jobs like care jobs and all of that, and I see them and I don't know whether I should cry or whatever. But with all arbitrates, when you are there online, you can do your matter from any part of the world and earn money. And that is the level that we want us as lawyers to be. Yes, it is good to go to court. Yes, it is sometimes it's not good when you go to court and they tell you that the matter is not going on, then you have to go back. Yes, it is good when you sit in court and you have SANs, like 5 of them or 6 of them, and then your matter go on till, maybe 4 p.m. And by that time, the court just says, let's take another date. That is to let you know that our judiciary is overwhelmed with cases that should go to arbitration that people are still bringing before them. I also want to mention a particular case, a particular thought. Every time we take commercial matters to court, I want all of us to know is going to slow down criminal matters. Whether it is a criminal judge or a judge sitting in a civil matter, the fact is that the dock of the court is full. And that's the reason for most of the delays, even in criminal matters. People come even to courts for, cases that they should have just resolved through arbitration in 1 or 2 months. The next slide. So the benefit is that it allows us enhanced transparency. People are afraid. Most of the time in traditional arbitration, you do it by writing a letter. The Arbitration and Mediation Act of Nigeria was promulgated in 2023. And Nigeria, from that innovative law, recognizes arbitration as a way to resolve disputes. And I would like everybody to try, in your spare time, pick up the Arbitration and Mediation Act of 2023 and just take a read and see the freedom that has been given to lawyers, to those who have arbitration certificates that have never sat for one arbitration in their entire life, but they have paid $250 to an institution to train them on arbitration and mediation. And that's what is happening all over Nigeria now. Everybody has certificates, but nobody has been able to sit on a particular arbitration or mediation matter. And I don't think that is a good development for us. If our court is still being overwhelmed, institutions are still making money from training people and collecting that amount of money, and you who has that certificate and that skill, you have not sat down in any arbitral panel or as a lawyer in an arbitration proceedings, that is not good for our professional development. So we need the transparency, we need it to open. So in traditional arbitration, and people go to institution, there is a clause in that act that says that if both of you cannot agree on an arbitrator, because both parties must agree. If I choose an arbitrator, if you find out about that arbitrator and you notice that probably that arbitrator went to school the same time I went to my own university, or that arbitrator worked in the same law firm I used to work before, and you feel that this arbitrator might not likely be fair, you have the right to reject that arbitrator in a sole arbitrator arrangement. And then if I now say, okay, you choose your own, if you bring your own and I tell you that, no, I don't also have confidence in that arbitrator, the law says that we are going to have resort to a particular authority. You can agree that in your contract to say that if both of us do not agree, we'll go to Shadat Institute of Arbitrators, or we'll go to the High Court of Abuja for them to appoint an arbitrator for us. So it means that you have appointed that institution as the designated appointing authority in case of disagreement. So what All Arbitrate is proposing is that if you put it in your agreement that the venue of your arbitration is going to be All Arbitrate for the sake of speed, you then state that All Arbitrate International will be the designated appointing authority. That will enable you to conduct arbitration securely online, within time and speedily. But in traditional arbitration, If both of you disagree, according to our law, you will have to write to either the Chief Judge of Lagos State to appoint an arbitrator for you. I don't know how long that will take for the Chief Judge to come back to you, but the Chief Judge is going to look at his own, a group of connection and look at a competent arbitrator who is known to him, and he will appoint him for you, and he will write you a letter. The letter can come very late, and by the time the letter comes late, you see the name of the person that the judge, the Honorable Chief Judge has appointed, and the arbitrator is telling you, yes, I know that your matter is the cost of the matter is 10 million, but my own as an arbitrator of 20 years experience, I'm going to collect 5 million. I don't care if your matter is 10 million. Will you go to that arbitrator? Will you still pay that money? Because both parties might need to share, or if one party sponsors the arbitration, the other party will have to, reimburse the winning party. I'm sure that commercially, nobody will want to take that route. So what all arbitrator has done is that it helps you look for an arbitrator that can collect a price that will not break an arm and a leg, because it is ad valorem. So you have on the website, you can pick an arbitrator. After reading the profile of that arbitrator, it will send a message to the other party that you have clicked on this arbitrator, and that other person will see a red and a green button, accept or reject. Once that person accepts, automatically that arbitrator will take over the case and schedule a pre-hearing conference, and the hearing can go on. The hearing can even be 2 times or 3 times, depending on the complexity of the case. And before you know it, the matter is over. But in traditional arbitration, you have to be exchanging letters, exchanging emails, appointing or constituting an arbitral panel might take months, weeks, and a very long time. And by the time they come back to you with pricing, we have seen situations where parties just run away. Once they hear the amount the arbitrator wants to collect, everybody just disappears. But that kind of thing shouldn't be happening when you know that you have a right or an obligation from a particular party has an obligation, but you have to abandon your right just because of the cost of arbitration. That is not a good practice, and that is what All Arbitrate has come to address. You can go to the next slide. Let me round up. So without much ado, All Arbitrate arbitration is the key to resolving website development dispute. Arbitration is the key to resolving even construction, any kind of commercial dispute at all. We are even advocating that in matrimonial matters, a part of matrimonial matters should be resolved through arbitration for the sake of the children and the minor. So, but for website development, arbitration is the only way, is the only key. And not only arbitration, a tech-driven arbitration on a platform like All Arbitrate is, and I can tell you this with all humility, no country on the planet Earth has the technology we have right now in Nigeria. If we all jump on this, the entire world is going to look at us as a new case study of where people can appoint arbitrators, even lawyers, on a particular website and do a video conferencing. Imagine that you're an in-house counsel in a particular company. Lawyers will come and meet you and say, oh, we were in court today. The court did not sit. You didn't see it. Sometimes I have been an in-house counsel. Lawyers have lied to me that they were in court, whereas they were not in court. But with arbitration, you can actually monitor every matter that is being held on the behalf of your company just by observing from your screen. So that is what we want to have with All Arbitrate International. I know the slide, we can send it to members, but I think I should stop here for further questions. so that I don't bore our listeners with a lot of it. All the step-by-steps, they are there. on my presentation, and I want to thank you for listening to me. Thank you, Mr. Chairman. Thank you, members of the bar and the ESCO.
Thank you very much, Mr. Kayode Adeniji. That was a very, very enriching presentation. It's so enlightening, and so it's very rich. It's quite rich. So, we are expecting a special guest, Mr. Folarisa. I don't know if our guest is around, or should we go on to
Let's
Q&A?
proceed.
Okay, sir.
Let's proceed. Mr. Victor is in the house to respond to any issues, and then if you have any questions for Kayode. But thank you very much, Mr. Adeniji, for that very insightful presentation. And I love the fact that you also highlighted the clause that you said you inserted. I mean, it's quite innovative. You know, I've been a part of resolving many website disputes, and just recently, you know, we had one with that even involved the NBA. But interestingly, this idea that even during the period of dispute or disputation, that it, including a clause to ensure it's like a safeguard clause to ensure that the website must still be up. You know, I think that is perfect. That should be that is a clause that should go into every website agreement. And you mentioned particularly, I mean, I can imagine how this would impact an e-commerce website or even a law firm's website. I was auditing a law firm's website recently, and you know, from the website you can do a lot of things. You can take instructions, you know, brief a lawyer. They have this AI handle that, or this AI interface that even does preliminary. That is a machine that they have trained that does some sort of preliminary advisory, you know, services. And I said to myself, imagine that maybe one of the plugins had an issue, or you know, whatever it was, and that led to a dispute, and you had to take down that service, you know, knowing that these services are subscribed to for a time period. Disputes affect businesses. In fact, it affects the online. It affects businesses that are online in very, very, very unique ways. You know, more unique perhaps than when you're dealing with a brick and mortar business. You know, so that's a very fantastic point. ePlan is actually preparing. We've put together a checklist for lawyers that we'll be sharing for those who have participated in the program. So thank you very much. We will definitely be including that clause there. Thank you very much. I think while your presentation was going on, I saw Mr. Adeboboye Adekunle, who is also a member of the CLE committee of the NBA Garki branch. Yeah, recognized, sir. Welcome, sir. I see Mr. Tinuke Adubi. You're welcome. My big sister, my senior, our leader at the bar, Mrs. Alero Okorua. Yeah, welcome, ma. So sorry, our special guest has not joined us yet, but like I said, Mr. Victor is in the house. So back to you, Asma. Then somebody asked. So Kayode was mentioning. Let me just
I saw a comment, sir, from Mr. Danladi Moses Adeuto.
Yes.
He said that the presentation is insightful. Thank you. However, you talk on arbitration, but did not mention the option of mediation. I am very sorry. It's because I'm very passionate. Because most of the time, you know, parties have disputes. So the difference between arbitration and mediation is that parties can choose the option of mediation. What's the difference between mediation and people, you know, they don't? Mediation is that process where both parties agree on terms of their dispute resolution. For example, you have done a website for me. We have dispute about money, and the mediator is there to moderate. It's not going to give a final judgment or award. And the reason why I'm hammering on arbitration is because, because our mind usually go to litigation. So I'm saying arbitration is the alternative to it. But I'm very sorry for that omission. So mediation, the mediator moderates. The mediator does not give a final resolution or award or anything. If the parties do not agree, whatever the mediator comes up with is null and void. So it is parties saying that, okay, you are supposed to pay me 8 million. I will collect 5 million. And the mediator asks the other person, are you okay with it? But this 5 million is going to pay you in 3 months. So say, no, he's not going to pay me in 3 months. He will pay me in 2 months. And both of you agree. The mediator writes down your agreement and then pronounces it as the final resolution of the matter, which cannot be appealed. So parties have the right. And on our platform, on All Arbitrates, we have a mediation option button. Once you come on it, it will ask you, what do you want? What service do you want? You want arbitration service or a mediation service? Once you click a mediation service, you will see the list of mediators, and then you can click, and the other party can say, oh, I want this mediator, or I don't want this mediator. It is different from the traditional mediation in multi-door courts, where the court just appoints a mediator. Whether you like him or not, it is not the problem of the court. Just go through it. But on all arbitrates, you can choose your mediator. The other person can reject the mediator. And as the designated appointing authority, our AI tools can then look for another mediator who can, moderate the matter and give you a final resolution in due time. Thank you, Mr. Danladi Moses.
Thank you very much, Mr. Kayode, sir. The highlights of the presentation that really took in are, he mentioned that arbitration just means we can do business across borders. It means lawyers can do business across borders. He also mentioned that if we are going to have any dispute, let the website keeps running. That's an interesting one. And there's this one, the alternative to be smarter and faster as a lawyer is through arbitration. These are very key words or key highlights that I think we all have to take away today from Mr. Kayode Adeniji's presentation. I'm going to open the floor for Q&A, and please do keep your questions straightforward and very brief. So you can either unmute yourself to ask a question, or you raise your hand, so that you'll be unmuted, or you ask a question, you write a question on the chat board. So you can go on and ask questions now. The floor is open for Q&A. As we wait for people to put in their questions, Mr. Kayode mentioned that everybody have a certificate of arbitration. That's so true. I mean, a lot of lawyers, even when we're in law school, they come and advertise arbitration and mediation, pay and get the certificates. But many people never really practiced it. Many have not sat on an arbitration case. So this one really got to me. This is so real, so real. So if you have a certificate in arbitration and you've never practiced, you've never sat on an arbitration case, you should go to All Arbitrates website. You may have an opportunity, to sit in an arbitration. Or what do you say, Mr. Kayode? There's a question here from Selzin. He said, many thanks for the insightful presentation. How can one come on board the All Arbitrate app as an arbitrator? Is Mr. Kayode still on board?
Oh, sorry, I've been speaking with my mic muted. Okay.
Sorry.
So if you have an arbitration or a mediation certificate, you know that certificate does not mean experience. I hope you can agree with me.
Definitely, sir.
Okay. So I just want us to be very clear and real with ourselves. So when you go on All Arbitrate, All Arbitrate will require you to tender your certificate. Obviously, you are a lawyer. So you can be a lawyer on All Arbitrate, because even if you are doing arbitration, people still need lawyers to present their case. A lot of clients might not even know how to operate this website. So this is an opportunity for lawyers to be able to operate this website and say to their clients, you know what? I know a place we can go to that can get this matter resolved faster. But you know what? We need the other party to consent. That is, if there is no arbitration clause in the agreement in the first place. Because our Arbitration and Mediation Act allows that parties can agree, even if it is not in the agreement. Parties can agree later on, whether through text or WhatsApp. So something that somebody did was that he lent somebody money, the person didn't pay back in line with the agreement, but they didn't have an arbitration clause. So the debtor was telling him that go anywhere, we appear there, even if you go to EFCC, because that's what people do. So I still have a case right now of a fintech company that gives people a lot of money, buy now, pay later, and people default and they go to police station. They tell the police to be writing those people and to invite them. 2 of those people have sued my client for fundamental human rights. One of them we were able to settle. The other one got a judgment against my client for breach of fundamental human rights, and the court awarded 12 million. This matter, we are just going to the Court of Appeal yesterday. Those who are on this, they will attest to the fact. But we've been telling this client, but they feel that, oh, don't worry, police will be fast. Police collected 10%, and then right now they are going to pay that 12 million. But I'm not a lawyer that would lie. I have to advise my client that, yeah, we are on appeal, but I do not think that you are going to, because if they had an arbitration clause in the agreement, that if this matter is breached, we are going to have an arbitration. All you have to do is just go to arbitration. Even if the party does not show up, you already have it in the agreement. You sponsor the arbitrator, the arbitration process by paying the cost and getting your final award. The next thing you do is to go to court for the court to adopt it as the judgment of the court and then levy execution straight and smart. But a lot of people, maybe they don't, or I don't know, and their in-house counsel, maybe they're not advising them well. They are where they are right now. So to answer your question, if you have a certificate in arbitration or your call to bar certificate, you can join as a lawyer. If you have the certificate, you can join as an arbitrator or a mediator, which means you need to go back to your textbook or do like a refresher of how arbitration process should go. If the panel or the ESCO will permit us to do like a technical knowledge sharing on the step-by-step of arbitration, just to refresh people's memory, because on that platform you will need to take charge of a particular case. You schedule meeting with the calendars and then schedule a video conference where the pre-hearing conference will take place. So what I'm saying is that certificate does not mean experience. Yes, you can come on as a mediator and arbitrator, but you will need to do a lot of refresher to just, freshen yourself up and say, yes, this case, I can take it. Or you have an arbitrator of like 10 years experience who is having an arbitration proceedings. The person can appoint you and press a button to say, join me in this arbitration proceedings, so that you observe 1 or 2. Once you observe 1, 2, 3, you can become an arbitrator and start earning money on your own rights. So it's just by going to All Arbitrate www.allarbitrates.com, and every other thing just goes smoothly like that. We were saying that people should pay 50,000, 75,000 for a particular year, but we realized that if we want people to embrace arbitration, the amount you have already paid to collect your certificate is already a lot. Without any result, without it fetching you income, it is better we open the All Arbitrate up free of charge for everybody. So we've been talking to our engineers to make it free of charge, but they said that if we do that, it's going to affect our code and it might disrupt the service that All Arbitrate is going to be giving to lawyers and clients. So what we have done, we have set the amount for 1,000 naira for anyone who wants to, because we don't want arbitration to be a classist thing. We want everybody to participate in arbitration, whether local or international, and earn money. Arbitration is not for some high-class lawyer. It is for anyone who is qualified, who knows that we need to resolve disputes and decongest our court. This is the greatest solution to court decongestion, in my own mind. Because I see attorneys general, I see our Chief Justice going into prison and giving people, opening a file of those who are awaiting trial and telling them to go home, and people are jubilating. It breaks my heart. But if we are able to ease our judiciary, we are able to ease them from all the backlog of civil cases, I am very confident that our the administration of our criminal justice system will be faster and smarter. So just see this arbitration as you are doing justice to the society by taking away your landlord and tenant. Even in tenancy agreement, put arbitration there. You put landlord and tenant and you take it to court. The same court that Mufutau, Moses, Austin, who have been accused of a crime that they are innocent of, and their innocence has not been proven for years. I think it's like blood on our hands as lawyers. So I am imploring everyone to please don't, yes, it is a technological matter. It means that we are on top of the world if we do what we are doing. But more importantly, you are helping the cause of justice in the world.
Thank you so much, Mr. Kayode. That's so generous of you. And this is something all lawyers here should take advantage of. It's an opportunity for your practice. So, sir, someone is asking, please, how can one get international arbitration certificate with UK affiliation?
CIRAB is the UK affiliate, Chartered Institute of Arbitrators, UK. So they have a branch in Nigeria. They are like, yes. So we have other arbitration institutions who are training people and appointing and becoming designated authority. But Chartered Institute of Arbitrators, UK, is the one that comes to my mind now. That's the one I have. But apart from that, countries are now opened to the fact that local arbitrator institutions should come up. And I want all of us to free ourselves from every colonial mentality. If you have an arbitration institution set up in Nigeria that is not foreign, you know the nitty-gritty of arbitration, you have read, and you know the process. That's all you need. You don't need any international or whatever. If you want to, fine. That is the one I have. But if I am to do it again today, I would do a Nigerian one. And that thing makes me, I don't know, there's a way it makes me feel. Yes, we got our independence from UK, but look at it today. In arbitration, we are ahead of UK with this technology because it's not available in the UK. Even UK, they are complaining of decongesting their own courts. Those are the people that gave us law. So we need to think ahead of the world. Nigeria is a nation of 250 million people. We need to continue to be creative and make our legal system responsive to world trade and investment. So if you find a cheaper institution that gives you good content, go and get that certificate. All arbitrates will recognize it. Thank you.
Thank you very much, sir. So I have a question for you.
Yes,
My
ma'am.
question is, For websites that collect personal data, compliance becomes a legal risk. At what point should data protection obligations such as NDPR or GDPR be addressed in website projects?
So that's a whole field entirely, because if you ask me that question, I'm going to be talking about data processor, because there are layers of data processing. There are people who keep data, there are people who process data. So the responsibility falls on different parties in the transaction. So this is a data privacy discussion, is a whole field entirely. So every website developer knows that most of the things I'm using to develop this website, they are not my material. They are the material of the client. So I, as the website developer, I am the processor of those data. But in the eyes of the world, it is your client that has those data. So if a website developer develops for me, everybody in the world will say that I am the one who has people's data, whereas it is my website developer who is another company. So I must be able to draft enough indemnification, indemnity clauses to cover myself as a party who process other people's data, knowing that I am not the one on the computer doing that, but my website developer, he becomes a data processor. So if I have any major dispute or court case or any kind of obligation to a third party, I will have to refer to my indemnity clause with my website developer. So excellent. It is also a standard clause to note.
If someone else is speaking, okay, sir.
If I may, I think we addressed this. I think I mentioned this during the first session where we talked about. I think I was talking about five clauses to include in your website development contract. But it was a tangential point because this reference is specifically to a certain type of website. I know that there's a huge fuss about data protection. Data protection is not new. It is a subset of privacy law. Unfortunately, it does appear there's this craze or this frenzy about data protection. It's not new. We've always had data protection laws, but they've been built into the common law and into some other laws. So I would say that there's a website development contracts are a subset of a broader scope or broader type of contracts that are ICT contracts or ICT law contracts, and with regards to websites that are outward facing, that they need to require to, in fact, all websites collect information, actually. Talking about, I know Mr. Victor is here and he might be able to tell us some of the technical parts of that, but all websites these days collect data. They collect data regarding your IP address. They collect cookies that collect information about the type of device you are using, the type of browser you are using, the maybe even the ISP that you are using. And there's all sorts of data that is captured and collected when you visit websites. And that is different and distinct from websites that handle. So that is one level of data collection. I know, again, this doesn't speak to, it's not part of our core discourse, but I just felt maybe I should shed some light on it. Then at another level, you have websites that collect data from people, in the sense that websites that collect data from people as a part of or as a function of the business. Yeah. Now, with regards to, I wouldn't really want us to go much into, because I believe Nigeria, we've made a lot of mistakes. I think data, if you look at the privacy law, is actually a state law. Privacy law is a state law. It's not a federal law. So just like the ACJA, states have to make their own data protection laws. So the Data Protection Act, in my opinion, is not does not apply to the entire country. It applies only to the FCT, but that's a different conversation entirely. So for websites that capture data from people, there are policies, as Mr. Kayode has said. It is important, and this is where lawyers now come to play. We as lawyers have to draft the necessary policies to ensure that, number one, there is compliance with whatever regulatory or legal, what's it called, jurisdiction that this information is to be collected from. I wouldn't want us to go too much into data protection, but I know there's a huge frenzy in Nigeria. I think a lot of it is wrong, in my opinion, but I mean, we'll have that conversation on another platform at another time. But
thank you, sir.
I was saying that there are two levels of,
yes, sir. There's
there
a
are two levels
comment
of
here.
data collection. Yeah.
Okay.
Okay.
Yes, comment from Osaro. I don't know if it's a he or a she. She said, I assume she's a lady. She said, hello, I'm from NDPC. Most times, the commission looks at the owner of the website, just like Mr. Kayode said. Controllers must ensure that the processors must comply with the NDP Act. Agreements between the controller and the processor do not save either party, as they both share liability in the event of a violation, although the controllers bear greater liability.
Okay, so what I want to say, what I want to say to that is I read the comment. So for lawyers drafting this sort of agreement, data protection is a regulatory matter. If you breach it, what we are saying is that if there is a breach and there is a penalty, terms of agreement can reduce the cost or the loss you suffer when you are being penalized for the breach of data protection. So that's what I was explaining about the owners, the processors, and those who own the website. So if there is a penalty, yes, he's saying both of them will bear the brunt, but most of the time, if we look internally and we realize that, oh, it is your fault, you have to indemnify me. It is not a matter for NDPC at all. It is a contractual matter between the party. Yes, they will satisfy the Data Protection Authority by ensuring that they comply, whether by paying cost or the penalty. But you need to protect yourself through contractual agreements. Thank you.
Thank you very much, Mr. Kayode. There's another comment from a participant. Is asking, no sufficient framework for online arbitration in Nigeria.
That is why we are on top. That is why we are on top of the world. Yes. Okay. So that is why we are on top of the world in online arbitration. So on all arbitrates, we have our own rule of online arbitration. And if you go to the website, you download the rules and read it, you will see innovations that no nation is thinking about. From when you are giving evidence online, how do you give evidence online? Or a witness is giving evidence without, cheating or somebody telling him at the background. All of those things has been thought out by arbitrates, all arbitrates, and everything is on our website. Thank you.
Oh, okay. How will parties enforce the award from all arbitrates platforms?
You enforce the award just like you enforce any arbitration. So what enforcement comes when one party refuses to comply with the award, right?
Yes.
So if there is an award, parties comply, they pay or they do whatever they are supposed to do as at when they find. But if they don't, that award is taken to court, just like every arbitral award. You take it to court for the court to adopt it as the court judgment, so that once it becomes court judgment, you can enforce. So what we have done with online arbitration is that we have cut away you filing in court, a registrar telling you, come, I'm going to serve, give me money. If you don't give me money, I will not serve. All those nonsense, we have cut it off by arbitration. So what you are doing is that you are owning the entire process. And after the award, that is when you will now go to court to say, okay, I want the court to adopt it as the judgment. That time, you have saved yourself a lot of headache as a smart lawyer and headache for your client. That's it.
Interesting. Thank you so much. Sir, as a futuristic lawyer that you are and a very innovative individual, I have a question for you again, sir. Please don't be, I hope you don't mind, sir.
No problem.
Okay. With the growing use of AI tools, no-code platforms and cross-border developers, what emerging dispute trends should lawyers and business begin to anticipate in website development contracts, sir?
So right now we have AI tools that so what the realm we are right now with AI is we are in the age of large language models.
Yes,
So
LLM.
those are just the type of AI that is prevalent right now. But you see, we are going into the realm of generative AI. You see, those ones can think for themselves. Those ones can process things and behave in a way that is out of our control. What we are advocating for is that please do not let, in whatever agreement you are going to draft for website, don't let AI replace human. Do not allow it. People are saying AI can be a judge in an arbitration case. Don't allow it. And in our rules on all arbitrate, we have said that anyone, any party must disclose their use of AI to either the tribunal in anything they are doing. If you do not disclose, you have that's like a penalty on the platform. So the use of AI must be in such a way that we humans put ourselves in the middle of it to control it. So do not allow anyone to write you a code that will replace human. No. Yes, AI may be faster, but AI does not have our emotion. AI does not know our special disputes. And a lot of even the large language models that people are constructing or building right now does not have a lot of African context inside it. It is all American, British, and other developed world content. So we need, as Africans, to continue to put ourselves within the system. So you can't use AI on all arbitrate. AI will never be a judge on all arbitrate. Anything that is artificial, any artificial intelligence, artificial human, artificial reasoning will not be allowed. AI will be our slave forever. It will only help us to be faster. It will help us to be more efficient. But especially in the legal profession, we must not allow it. And that's why I'm so proud, because if we leave AI or technology in the legal space to people who are non-lawyers, who don't have legal license, who don't have anything to protect, they will destroy this profession for us all over the world. So what we are doing in All Arbitrate is ensuring that we guide our technology in such a way that it will only propel us. So in whatever agreement you are looking at, in AI should not replace human. AI should always require human approval to do certain actions. It should not just be automatic and just working like that. So thank God we are still in the age of LLM. Things are still under control. But by the time we get to that era of generative AI, we need to have another conversation for that particular dispensation.
Wow,
and
thank you
we
so
are
much,
fully
sir.
prepared for it. Yeah, thank you.
Please, the lawyers on board, can't you give Mr. Kayode a virtual applause, please? Are you not enjoying this conversation? Because I'm so into it.
Not just the lawyers, everybody.
Okay, everybody. Everybody, sir.
So very quick housekeeping before we go to Mr. Victor Idowu. And like we mentioned earlier, there's a special announcement that we have at the end. Before we go to Mr. Victor Idowu, very soon, any moment from now, we'll be sharing the link for CLE and the feedback form. So please stay tuned. We'll be sharing the link for feedback form and our CLE points. Thank you.
Thank you, sir. So, sir, let's welcome Mr. Victor. He was here last week, and right now I'm even short of questions to ask him because he covered everything that we needed to ask. But if you have any technical questions right now, you can throw it in.
Or if Mr. Victor has anything to
Any
share.
contributions? Yes.
Yes, Mr. Kyle, Mr. Victor told us about a dispute. I'm actually aware of that incident, that situation. He had developed a website for a particular, maybe one of the, a Nigerian, one of our Nigerian leaders. And there was an issue, one of the aides, there was an issue somewhere. And at the end of the day, they took the dispute to cybercrime units.
I
the
remember.
Nigerian police to resolve.
Remember, he mentioned last week.
He's always happy to, yes. So that's one way of resolving disputes. Although that way, I don't think it didn't pan out very well for them. So maybe Mr. Victor can share some of his experiences in relation to some is it best practices now? Some of his experiences and some best practices from the point of view of a practitioner, a developer.
Thank you for this opportunity again. Mr. Kayode, thank you so much. Mr. Kayode, you have lectured me today. So I'm here today as a learner. I've learned a lot from the things you have said. Thank you so much. And although you were biting me and biting people in my corner with some points, but I think you balanced it eventually. Let me tell you where you were biting us. You mentioned that if there's a dispute, that there should be a clause that the site or the digital asset should keep running all through the period, even as we are trying to settle the dispute. I've experienced that before, and after that first experience, I can say the outcome was not fair to me. So,
Wow.
yes, it wasn't fair.
I may have to interject here because I don't know if that experience is the one Victor is talking about. That interestingly, and is it the one that involves lawyers, Victor?
Not even that one.
Not that one. Okay.
Because share the one with lawyers. Share the one with lawyers.
Yes.
Oh,
there was a dispute that Victor, in fact, he was so gracious. Victor ensured, and we were involved in that incident. I was involved, and Victor ensured that the digital asset actually, remained, was maintained. But then you had two disputing entities and one digital asset, and at the time, I think hosting was abroad. It was GoDaddy, I think, and you were paying in dollars. Yes, you used your funds to maintain the asset, and at the end of the day, the question was, who do you hold? But just on a lighter note, and just to co-sign, what you're saying.
Yes, thank you for that. In fact, I had almost forgotten about that. Now, the one I'm even talking about, as in the one I remembered and I wanted to share, was with an organization, and yes, we had payment plan, and they are supposed to comply at this point or at that point. So for the first tranche of payment, yes, that was done well. The second one, they failed on the second one. But in spite of that, we proceeded until the fourth stage of the development. So at the fourth stage of development, they were comfortable with the outcome already. It was giving them the success they needed and all the rest. And they now want to renege on what we had agreed, and then started bringing more. Okay, for the fact that, oh, for paying the first tranche, you could achieve this. Okay, add this. You need to do this. You need to do that, which was not in the initial agreement. But then we had agreed earlier on that nothing will bring the asset down. It's not, the reason I'm calling it asset is because it's not just a website. It's a whole business. It's a whole business. So the fact that we had, and the funny thing about it was that the commitment to ensure the digital asset keeps running is oral. It was an oral agreement. It was oral. I mean, we didn't have that in writing. It was just a personal commitment. It was just something that we had discussed, and I'd given them my word that we won't use our own hands to bring down what we had built. So it went on like that, and then when the disagreement came, they will keep reminding us, you cannot bring this thing down. You cannot bring this thing down. Until well, the agreement was supposed to be for 2 years, and then we dragged like that for about 20 months. At the end of 20 months, we needed to lock it, at least lock it or prevent people from accessing it, because once our 2 years agreement is done, there's nothing else to leverage. I hope you understand me. So in the long run, we locked it at the 20th month. If I'll put it, okay, let me put it in proper context. Within that period of time, the company had made I think 68 million naira thereabout now. 68 million naira. And the commitment, that 68 million naira that I'm talking about is in profit. Nothing else, just profit, because they were selling things online and the rest. And what they had committed to the entire project was about 4 million naira, 4 million naira thereabout, out of a commitment of 10 million. So at the 20th month, we decided to lock it down. And then doing that, oh, police, this, that, you know how we do, you know how we are in Nigeria. Getting to the police station, police said the first thing you need to do is to unlock it. Who can respond to how we are, who can answer to how we are supposed to respond in that kind of case, please? Let me hear our opinions.
Okay, Mr. Victor is asking that who can give an answer to this kind of situation. There are lawyers in the house. We want to hear you. Please speak up.
Okay, let me proceed. In a nutshell, eventually we unlocked it, and then the police agreed. The police said we should give them 2 months more. We gave them 2 months. Within the 2 months, they made extra 15 million thereabouts, 15 million 7 or something. I can't quote the exact figures now. After the 2 months, we went back to the police station. Oh, this is what has happened. They've not complied to what we agreed on, and the rest, like that. By the 3rd month, that's a month to the end of the entire contract. Of course, they were wrapping up, and then they said the thing was not done well. It impacted them. That's the locking that we did for about 48 hours thereabouts. Impacted them negatively. They are no longer interested in the project. Back and forth. In short, they were not going to pay again. I must tell you, till date, that conversation died there. They didn't pay up, and then we moved on and walked away from it. But then some other projects came on board, and that clause that Mr. Kayode mentioned was something I declined. Instead of, okay, if we are going to do this, is going to be, because we have to make it balance. But Mr. Kayode balanced it with arbitration. That's what I'm saying, actually. He balanced it eventually with arbitration. So that's why I said I love what All Arbitrate is doing. I mean, it's
I'm
going to
sorry for
solve
biting
a
your corner,
lot.
sir.
But what you have done is going to solve a lot of problems, a whole lot of problems. Because subsequent deals that came, I will say we can give a window. We can give a window of 3 months to resolve whatever we need to resolve. If we cannot resolve it within 3 months, we are going to do X, Y, Z. And that was a lesson for my organization also. We don't wait until they are wrapping up, or I mean, most times website agreements are in 1 year, 2 years, and co. So if we cannot wrap anything up in 3-4 months, we will start hammering for all our rights. Whatever we need to get, we need to start insisting on all of those things before the expiration of the agreement. So with All Arbitrate now, I think it's a good idea, because without this kind of solution, I always insist 3 months is the maximum that we can resolve for. If under 3 months we cannot resolve, we lock it. So if you cannot agree to that, it means you already have it in the agenda. And to not even get us to that point, we try as much as possible to make the agreement very fair, very plain, so much that when any side is goofing, you will know. It will be very, very clear, because the agreement is not ambiguous. It is clear. You will know that I'm intentionally doing this, or go back to the other party to say, please, I apologize. I know this is not our agreement, but this and this is what happened. And please, you need to understand with me and the rest. So that's to answer to Mr. Kayode's position. But All Arbitrate is going to do well with that. Okay. We were talking about data collection also, I had Mr. Folari. He was talking about the types of data. We have personal data. Personal data, that's the information that identifies individuals directly. This one includes name, email, the address, phone number, photos, all of those things. In fact, most times we submit those ones. But then there are other data that we don't even know we are submitting. And then anybody could be held liable for that kind of data. We have behavioral data. How many of you have you visited? I mean, sometimes you visit some websites and then you see a particular advert following you everywhere. Have you seen that before? You are on this website, you are seeing this company advertising.
Many
and
times.
then you move to another website, you see the same company again. You say, their budgeting, their marketing budget must be very huge. They are actually using your data we call it remarketing. They are using your data to follow you everywhere, so that they will be on your face everywhere you go on the internet. So that's part of data extraction. They use browsing history, pages visited, then the time you spent there is data. The clicks you make, the scroll depth is data. And then the advertisements you engage with is data also. Sometimes they even go into your purchase history, product usage, download history, and go. And I must tell you, this is a very big industry. There are a lot of data that you don't submit. You don't submit this data, but then the controllers of the website, the developers or the owners of the company, they extract this data. You may not see it as personal data, but if we put it in proper context, I can call it personal. Because your IP address, you don't know it is personal. I know it is personal. Your IP address, and once I get your IP address, and I know the times you browse, I know your IP address. I know this IP address is active at so and so time. This is the time of the day that you are always online, and then these are the kind of website you visit when you're online, and go. I can target you based on that data. So I'm sure a lot of these things will be considered in all arbitrate. We also have common collection. We have online tracking. We have form registration, which we do ourselves. Surveys and feedback, we do those ourselves. We have analytics and then social media. A host in fact. Mr. Kayode said it is a whole topic. It's a whole topic. It's on. So that's my 2 cover on data. If there's any question, I can take any question.
Thank you very much, Mr. Victor. That was a very insightful contribution. I didn't know about behavioral data before. I'm just hearing it for the first time. For the question you asked earlier, I would like to ask Mr. Folari to please do us the honor of giving an opinion on that. Thank you, sir.
Sorry, Asma, what question was, which question exactly?
Okay, Mr. Victor, can you ask the question again, sir?
Okay,
Please go ahead.
I was asking about the fallout between the developer or the developer, that's my own organization, and the client, and how should the issue, how should it be settled? I mean, what approach should we have used? That was what I was asking.
Oh, that's question. Okay. Well, you know, I'm a stickler for mediation. You know, for ADR. You know, and I know Kayode says he's an arbitration person. I'm a mediation person, and I believe all arbitrates does both arbitration and mediation. You know, because I think mediation tends to be, you know what, I was somewhere sometime, and there were these police officers, and you know, a senior police officer was asking them, the police officers were saying, oh, we mediated between the parties. And then their superior said, if you had mediated, why is somebody going to Brekete family to complain? You know, and my comment was that, you know, I don't know what kind of mediation would happen in a police station, you know, or in a police formation. But the fact that there's a subtle element of a threat of arrest, anybody would, you know, the person who is at the receiving end of that threat would agree to anything, any condition. Just someone said it's behavioral data, or, you know, just to secure their liberty. You know, I think using law enforcement or using law enforcement is definitely a no-no. And I would encourage lawyers to also to refrain from drafting. You know, sometimes clients come and they say, oh, we have this problem. And as Kayode had mentioned it, that there may be a tendency to say, oh, let's go to the police and draft this petition, you know, in such a way as to make it, this is a cyberbullying or cyber stalking, or, you know, or a threat of digital assets, or a theft of digital assets, you know, and so on. It's good for us as lawyers to always look for solutions that will help our clients and not harm them. You know, and by that help, you know, help that gives them long-term satisfaction. Because again, you know, a website, we're talking about website development contracts, and this is a subset of a much larger scope of agreements. But a website development contract is not a 100-meter dash. It's actually a long-distance race. You know, the amount you pay the developer, or your relationship with the developer, tends to be if everything goes well, it's actually it's like a marriage, till death do you part. You know, and most times disputes should not end in death. You know, so my feedback or my intervention would be, the best case scenario would be mediation. But for mediation to happen, both parties must be ad idem. and this also means that for what's it called? Everybody's ego, we all have to find ways to keep our egos in check. Of course, for the business owner, for every second that your website is down, you are losing money, you are losing clients, you are losing something, you're losing value. And God forbid, if it so happens that the website is down and the name lapses or the name expires, and the window within which the registrar would hold the name expires and somebody else picks the name up,
Wow.
that will lead to lead to all manner of
Wow.
And now we even have, when you even have situations where, you can layer that on top of all manner of scenarios. So I think mediation is a very good, or an arbitration, are very good pathways. And for me, this would be my first resort. But Kayode had said something, and I think Victor also echoed it, that your disputes, we have slides which, in addition to Mr. Kayode's slides, I won't share the slides. We'll send them to participants by email. But the best disputes are those that actually are resolved by the agreement, by the contract. And they are those that the contract anticipates and makes provision for, so that when the incident arises, the contract has provisions that can be put in place to ensure that both the developer and the client, that neither the developer nor the client, suffers. So that would be my intervention. Of course, and then you go down that line. So from ADR to perhaps litigation, before it can move on, down that line. Just to also quickly mention, I had the privilege, I was, I was a lead consultant on a team that reviews the penal code laws and the criminal code laws of some states, several states in the north, northeast, north central, southwest. And there was a particular state where we actually introduced some elements of cyber law, and one of them, some of the crimes had to do with theft of digital assets. And this goes to Mr. Victor's use of the word digital asset. And also to what Kayode had said, at the last session, that, whether you are a lawyer, as lawyers, of course, we have the digital assets. Websites are assets, and this is the property of the future. So it's important that we should keep it at the back of our mind that the things we are dealing with, this is not just a case. It's not just a brief. You're dealing with a digital asset. Thank you very much.
Thank you very much, sir. This is quite enriching and very insightful, sir. So we're still waiting for our participants to ask their questions. And
I think we can announce that the form, the CLE form, the feedback form is in the chat. For those who are on YouTube, I think we can just do a quick screen share for those who are on YouTube.
Okay, the CPD point form is here. The link to the CPD point is here. You can click the link and fill in your data. Then there's a comment I saw here that I'm trying to bring out.
I think I responded to a comment that says that the site is not user friendly. I mentioned the fact that we are crashing the price. The engineers are also, in fact, if possible, if you look at your waiting room, some of the engineers are trying to come into the meeting to see, the comments and be able to know. So they want to also ensure Google sign-in, which will make it easy for users to be able to. So we are doing a lot of work to open the website up and take away every financial barrier for lawyers to be able to, do their work efficiently and earn. Thank you.
Thank you very much, sir. I hope that answers your question. Let me see. Yes, Mr. Danladi Moses.
Yes.
Yes. Okay. Someone, Ali Musa Sagir, also have a comment here. We have benefited immensely in no small measures. Looking forward to more training for professional development. I think this is for the branch, and the chairman of the continuous legal learning education. So we are grateful for this. Thank you. I love this comment. This is what we do in Gariki branch. It's an innovative branch. We are not like I won't say more.
Don't say more off the mic, please. As well. We'd like to say thank you to our branch chairman, and most importantly, the two classes of people that I would really say thank you to are our facilitators and our participants. So a big thank you, very big thank you to you, to everyone. Mr. Bulusatin has joined us. Thank you very much, sir. I had mentioned earlier that there was a special announcement that we're going to make, and I knew that once we share the CLE points, that people will tend to, Mr. Mr. Olusegun Idowu, IPLAN people. So I had discussed in the course of a side conversation with Mr. Victor, we talked about, so I was telling him that, it would be good, yes, if we had our way, every lawyer would have a website, and will be available online. But hey, it is what it is. And Mr. Victor was kind enough to propose that some sort of partnership. We will, I'm sure we'll have to fine tune it. We haven't fine tuned it yet, but if you are if you're interested in, so Mr. Victor will be providing discounted. We've discussed with Mr. Victor, who are still negotiating, and he has been very gracious enough to agree on principle to provide discounted websites at discounted rates to lawyers. Anyone here who would like to take advantage of that. So what we will do for those of us who have filled out for those of us who are yet to fill out the link, to please indicate if you would like to take part if you would like to take part, or at least to learn more about the discounted website arrangement. We're trying to see how we can leverage on our relationship with Mr. Victor. So he shouldn't just come and tell us about his experience. He should also share with us from the depth and the extent of his skill. And I think, anyway, someone just sent me a message. I was asking who will draft the website development agreement with Mr. Victor. When we meet in the other room, we'll discuss that. But yes, Mr. Victor has agreed to provide discounted website development services to lawyers. I think lawyers should have, if we Google you, your website should be one of the first sources of information about you as a lawyer. And you don't even need to open a law firm. Kadi was talking about access to international practice opportunities through the All Arbitrates platform. Anyway, Kadi knows, I bought into the platform immediately when we had our first conversation. And All Arbitrates has been a very dependable partner. We had a session last year with All Arbitrates as well. And you guys are doing fantastic work. So well done, Kayode. Thank you so much.
And sir, I would like to mention, sir, sorry, sir, that for lawyers who might not be able to afford Mr. Idou's fee, just like what you mentioned, when we Google you, maybe apart from your Facebook, LinkedIn, Instagram, your profile on All Arbitrates also adds to your online footprint. So on that profile, please put in as much information for people to be able to access you as a lawyer. Even if you are not an arbitrator, just a lawyer, you can be there. Clients can talk to you and private chat you on all arbitrates. So we have a private chat where, because we do not want to interfere between lawyer-client relationship in terms of fee. So it is also available on that website.
I know it's 1,000. I know the registration fee is 1,000 naira, but can I maybe I would is one that I know every lawyer should have, but just for what is worth, Mr. Kayode, if anyone reaches out to you, a lawyer, and on principle or for whatever reason says, "Oh, I don't want to pay this money," I think I can pledge to register or to pay the registration fee for, is it 50 lawyers now? So 50 lawyers. So if you're interested, please just reach out to All Arbitrates and tell them that Mr. Falari's pledge. I'll happily redeem. Just give them your information, especially for young lawyers. Let's make it for young lawyers, but give them your information, your registration information, and tell them that you want to take advantage of Mr. Falari's pledge, and I'd be very happy to redeem. So the first 50. Over to you, Asma.
Thank you so much, sir. That was very generous of you. Thank you very much. So every young lawyers here, please take advantage of this. And thank you to Mr. Victor for the collaboration. This is going to be very, very good for lawyers, especially those of us who do not have website yet. So we are going to leverage on this relationship and try to have a website. Thank you so much. So please, I'm imploring all young lawyers here, take advantage of this. There's no better time to be known than this moment. There's no better time to put yourself out there and try to get clients across borders. Thank you so much, sir. So, sir, we'll be rounding up this session very soon. Do you have any more information to give, sir, Mr. Falari, sir?
No, I think maybe you could help with a vote of thanks. You know, as our profession is regimented, so I've said thank you to our branch chairman, learned senior advocates, and senior colleagues here present, senior members of the branch, senior members of the bar who are not from our branch, members of the participants, and in no small measure, our very, very, very resourceful resource persons. Thank you so much. And thank you for not only spending of your time and spending from the wealth of your knowledge. You've also given us something to hold on to. So thank you very much for that. And thank you to you, Asma, as well. Thank you very much for doing a fantastic job as moderator. I should mention that there are some people who have been working in the background to ensure that today's program holds very well. Some people that have been shooting messages and emails back and forth. Hannah Shiloba, Barrister Hannah Shiloba, thank you very much for your work. I know that the All Arbitrates team too have been fantastic, ensuring that today's session holds. Where can you find Mr. Kayode Adeniji? You can find Kayode Adeniji on LinkedIn. He's very active on LinkedIn and on other social media platforms. I believe the same thing for Mr. Victor Idowu. So I'd encourage you, please take the conversation up with them on LinkedIn. And please, it's also very important, you know, we've had a very robust session here. I would encourage us to please go to go to LinkedIn. Let us continue the conversation there. ePlan has a page on LinkedIn. ePlan also has social media pages, everywhere. The same with MBA Garki, the same with all arbitrates. Please let's go and engage there. I'd encourage us to please engage there, so that we can drive the conversation forward. Thank you very much once again, everyone. Asma,
Please, I would like to ask Mr. Kayode and Mr. Victor to drop their handles so that we can follow them on their social media platforms. Please drop your handles on the chat. I would like to give a special thanks to Mr. Victor and Mr. Kayode and Mr. Folari Aluko. Thank you very much. And also, I'd like to give a special thanks to our audience for a very practical discussion. What is clear is that most website development disputes are avoidable when parties clearly define what is being built, who owns what, and who is responsible for what and when. So on that note, thank you all for your participation. I would like to give a special thanks to our branch chairman, Mr. Bamidele Kayode Ojo. Thank you so much for giving us the opportunity to learn, and the chairman of the ICLE, Barrister Folari. Thank you so much for always giving us the best. We bringing up the best people on board, and who are able to give us a whole lot of knowledge. Thank you so much, sir. I would like to also thank our publicity secretary, sorry, Damilola. So I'm sorry. Thank you so much, Damilola, for all you do. We see your work, we see your hard work. You're behind the scene doing a lot. Thank you. And every other person working behind the scene. Thank you very much, everyone who has participated today. God bless you all. So on that note, I would like to move a motion that this session should come to an end. I need someone to second the motion. Okay, it's seconded by Shuaibu. Let me see. Yes, Shuaibu Yahya. Thank you so much. So on that note, we'll be closing down the meeting. Have a very good evening, everyone. Thank you so much.
All right, thank you, everyone. So I'll keep the meeting room open for the next 4 minutes. So when it's 5 minutes after 6, I will shut it down. In the meantime, I will keep reposting the feedback /CPD point link for those who are yet to fill it. So you can take advantage and fill it in the next 4 minutes before the meeting is shut down finally. Thank you.
Thank you, Dami. Thank you very much. I think that's why I was lost. I wanted to pronounce your name completely because I usually refer to you as Dami. So pronouncing Damilola was a bit difficult for me. Thank you so much, Damilola.
You're welcome, Asmao.
So if you have not filled the CPD form, please do take this little time left to fill the form. Please, the handles, were they able to drop their LinkedIn handles? Okay, I've seen that of Mr. Kayode. Someone asked, Aisha Farouk said, please, how can we reach out to Mr. Kayode? Okay, let me drop his handle. If you are still on board, Aisha Farouk, this is his handle name, Abi handle, rather, Kayode F. Adeniji, for both LinkedIn, Facebook, and Instagram. How about Mr. Victor? I'm not seeing his own. You're welcome, Salamat. Thank you too for staying till the end of the meeting. You can copy the link and paste it on your browser. Yeah, I'm sure it will open. Copy the link, paste it on your browser, the form will open. Thank you so much, Raphael. Thank you very much.
Everyone, bye.
All right.